Okay. I think we are live. We're going to begin now. Ladies and gentlemen, esteemed guests and fellow colleagues, it's my distinct honor and privilege to address you today on the crucial and evolving topic of merger control issues in the GCC states, with a particular focus on the regulatory landscape in Saudi Arabia and Kuwait. Today, we have speakers from both the regulators as well as my colleagues from GLA and Company. From the Saudi General Authority for Competition, we have Mr. Talal Al-Hagail, M&A Unit Head. From the Kuwait Competition Protection Agency, we have Ms. Shahad Al-Saqabi, Head of the M&A Department. From GLA and Company, we have Asad Ahmed, Head of our Antitrust and Competition Practice. We also have from GLA, Khalid Al-Makhazim from our Kuwait office, and Mr. Hussein Bun Nejma from our Saudi office. And I'm Alex Saleh. I'm the managing partner for GLA and Co. As I've been in the GCC practicing law for over 30 years, I can tell you I'm amazed by the development and growth of the regulatory bodies here. And the GCC as a whole has experienced remarkable economic growth and diversification in recent decades, attracting substantial foreign investment and fostering an increasingly competitive business environment. As a consequence, the need for effective merger control regulations to safeguard fair competition and prevent anti-competitive behavior has become increasingly pronounced. In Saudi Arabia, the government there approved the long-awaited competition law in 2019, which included provisions for merger control. The law aims to promote fair competition, combat monopolistic practices, and regulate mergers and acquisitions that may substantially lessen competition in the market. The Saudi competition law is administered by the General Authority for Competition. Big controversy. Do we call it GAC or GAC? We're going to ask Talal that because I always hear both sides when I hear it referred to. I don't know which one sounds better. Turning to Kuwait, the country's competition law reenacted in 2020 and the regs in 2021 also included provisions pertaining to merger control. The law prohibits any actions that may lead to the abuse of a dominant market position and regulates mergers and acquisitions that could substantially lessen competition. The regulatory authority responsible for implementing the competition law in Kuwait is the Competition Protection Agency, the CPA. As the global economy becomes increasingly interconnected, competition authorities are enhancing cooperation and coordination to address cross-border mergers and acquisitions effectively. This trend underscores the importance of understanding and navigating the regulatory landscape in multiple jurisdictions for businesses engaging in international M&A activity. The evolving merger control landscape in the GCC states, particularly in Saudi Arabia and Kuwait, presents both challenges and opportunities for businesses operating in these dynamic markets. Understanding the intricacies of merger control laws and staying abreast of global trends is essential for businesses to navigate the complex regulatory environment and achieve substantial growth in an increasingly competitive world. GLA has been at the forefront of this development, with over 100 lawyers between ourselves and our association with Habib Al-Mullah and Partners, our 7 offices in the 5 jurisdictions in UAE, Kuwait, Saudi, Egypt, and Lebanon. We have a well-established practice area in all the main groups, including corporate banking and finance and dispute resolutions. However, we are especially proud of our antitrust and competition practice, where we can confidently say is one of the most only dedicated and largest practices of its kind in the Middle East. We deal regularly with both the CPA and the GAC between our Kuwait and Saudi offices. I believe we handle around 40% of all filings in Kuwait, for example. These last few years have just been amazing as we work with these wonderful regulators from both these jurisdictions and looking for common sense solutions as we implement local, regional, and international M&A deals in these important jurisdictions. As such, we want to share this experience with you today on these practical considerations whether one is navigating through the GAC or the CPA. With respect to the remaining agenda today, it's going to consist of the following. We're going to do a high-level review of the merger control laws and regs. We're going to have some frequently asked questions with the regulators. We're going to ask, we're not going to have time to do an open live Q&A session, but we're going to do a Q&A chat where you put together your questions, whether for us or the regulators, and we promise to get back to you with your email information very shortly. And then we're going to go through our closing remarks. So thank you for your attention, and we look forward to engaging in insightful discussions on this critical subject. At this point, I'm going to turn it over to Asad with respect to the high-level review of merger control laws and regs.
Wonderful, wonderful. Thank you, Alex, for that introduction. Again, my name is Asad Ahmed. I'm the head of Antitrust and Competition Department in GLA and Company. We're truly pleased to have such a great turnout for this event, and thank you all for joining us. As Alex said, antitrust and competition has been a very hot area in the GCC in the last couple of years, specifically in KSA and Kuwait. Without any further ado, we will first provide a high-level overview of key elements surrounding the competition law and economic concentration filing procedures. We will then move on to the regulatory side with Talal and Shahid from the GAC and CPA, respectively. I'm going to bring in my colleagues, Hussein and Khalid, and we're going to go with the first question with Hussein for KSA. What are the current laws that govern merger control and competition in your jurisdiction in KSA?
Yeah, thank you, Asad, and hi, everyone. So here in KSA, we have the competition law, which was issued by Royal Decrees number M75 in 2019. And we also have the implementing regulation of the competition law, which was issued by resolution number 337 in 2020. And we also have the merger review guidelines version number 4, which was published in November 2023. So that's it for Saudi Arabia.
Okay, thank you for that. Same question for Khalid. What are the current laws that govern merger control and competition in Kuwait?
Yeah. Thank you, Asad. Here in Kuwait, we have law number 72 of 2020 and its executive regulations number 14 of 2021 with amendment number 25 of 2022. Those are the regulations that govern merger control and competition here in Kuwait. In addition to resolution number 26 of 2021, which regulates specifically the financial threshold.
Wonderful. So both jurisdictions have recently enacted these regulations, as Alex alluded to, along with the respective financial thresholds. So we're going to move on to the second question. And when is notice required? So let's start with Khalid for Kuwait. When is a notice of an economic concentration required in your jurisdiction?
Yeah, it is required when an economic concentration situation and the financial threshold are met as a result of a commercial transaction. Economic concentration is a situation involving a permanent change of control in the relevant market, arising by way of merger or takeover, as well as establishment of a partnership between two persons or more, providing an independent economic activity on a permanent basis. In the case that the transaction fits with this definition, the parties to the transaction must then meet the financial threshold during their last fiscal year for the notice to be required, which is either one of the parties have generated a revenue that have exceeded 500,000 Kuwaiti dinars, which is equivalent to $1.6 million, or both parties have generated a revenue that have exceeded 750,000 Kuwaiti dinars, which is equivalent to $2.4 million, or both parties have a registered assets in Kuwait that exceeds 2.5 million Kuwaiti dinars, which is equivalent to $8.1 million.
Okay, thank you so much for that. That's very interesting. And and I'm sure that is quite broad with respect to the transactions that would fall under those categories and those numbers in Kuwait. Let's move on to Hussein for KSA. In KSA, what would be considered a required notice with respect to economic concentrations?
Yeah, Saad. So a notice is required for economic concentration transaction. And first, we need to ask what an economic concentration is according to the Saudi competition law and its regulation. So we can define economic concentration as the following. Economic concentration involves the total or partial transfer of ownership of assets, rights, stock, or shares, or obligations. It also includes the combining of two or more management into one joint management. This encompasses arrangements such as mergers, acquisitions, takeovers, or any other transaction forms that result in the control of a firm or firms. With respect of the element of controlling a firm or firms, it is defined as the following. Control includes influencing decisions, shaping administrative structures, or affecting voting systems. Then, we must make sure that the economic concentration will meet with the current thresholds. And all of the following thresholds criteria must be met. First, combined worldwide sales of the economic concentration parties must exceed 200 million Saudi riyal, equivalent to 53 million US dollar. Second, total worldwide annual sales value of the target establishment exceeds 40 million Saudi riyals, equivalent to 10 million US dollar. And finally, collective annual sales within the kingdom by all economic concentration party must exceed 40 million Saudi riyal, equivalent to 10 million US dollar. So that's it for KSA, Asad.
Okay, wonderful. Thank you for that. I think it's important to note that the distinctions between the jurisdictions here with respect to the financial thresholds. So for Kuwait, for example, only one of the financial thresholds needs to be met as compared to KSA, which was recently enacted and changed with respect to their financial thresholds, where every single one of the financial thresholds must be met. Otherwise, it would not trigger a filing there. Let's move on to the next question. Exceptions to applications. So Hussein and KSA, are there any exceptions underneath the merger control law or the competition law with respect to filing an economic concentration?
Yeah, sure. So an exception is granted for transactions that do not result in a change of control. For example, acquisition of minority interest with no vote right over strategic decision, or internal restructuring within the same corporate group. And also public institution and government-owned companies, if they are slowly authorized by the government to supply a goods or service in certain field. So this is the exception here in Saudi Arabia.
Okay, wonderful. Thank you. Same question for you, Khalid, for Kuwait. Are there exceptions for filing an economic concentration application with the CPA?
Yes. The law here in Kuwait exempts certain activities from being deemed economic concentrations. First, the banks, insurance companies, and financial institutions whose activities include trading in securities, provided they do not exercise substantive voting rights conferred by such securities, and the security must generally be disposed within 1 year from the date of acquisitions. Second, the acquisition resulting from insolvencies, defaults, debt restructuring, compositions with creditors, or similar transactions. The most popular exception utilized under the law is restructuring within the same group of companies. Also, the transactions that do not result in a change of control are exempt also.
Wonderful, thank you for that. I think it's good to note that the CPA has accepted on multiple occasions the restructuring exception from our applicants on multiple occasions. So we were successful in doing that, working with Shat. Let's move on to the next question here. Consequences of a failure to notify. So Khalid, with respect to Kuwait, what would be the consequences under the law if parties to an economic concentration have forgotten to notify the CPA or just chose not to notify the CPA and file an application?
The CPA has a disciplinary board tasked with deciding disciplinary actions in relation to violations of the law. The disciplinary board may impose financial penalties up to 10% of the total revenues generated by the parties to the economic concentration during the preceding financial year, in the event that the parties did not file for an economic concentration application.
Okay, thank you for that. I think it's important to note also that that figure is global, right? The revenue is based off of global numbers and not local turnover there. Hussein, with respect to KSA, what are the consequences for parties to if they fail to notify the GAC with respect to an economic concentration?
So if an establishment fails to notify the GAC as per Article 7 of the competition law, that will trigger Article 19 of the competition law, which will be the following penalties. Fine up to 10% of the total annual sales value related to the violation, and alternatively, a fine up to 10 million Saudi riyal, equivalent to 2,600,000 US dollar, if estimated sale is difficult. And the committee can impose a fine up to 3 times the gains obtained from the violation.
Okay, thank you. Thank you for that. I think it's important to also note there that the GAC has the ability to estimate even under the law if the parties cannot or refuse to provide an annual turnover there. Let's move on to the next question here. When are foreign-to-foreign transactions notifiable in KSA, Hussein? This is a big question. You know, we generally have quite a bit of international clients, and it's a very popular question when it comes to foreign-to-foreign transactions that involve multiple jurisdictions. So, Hussein, can you give us a little bit of an insight on that part?
Okay, so when foreign-to-foreign transactions are conducted outside of the kingdom, but may potentially harm fair competition within the kingdom. And it's worth noting that the notification is required even if there is a possibility that the transaction could affect competition in the kingdom rather than certainty. And we need to make sure that the foreign-to-foreign transaction will not gonna fail under the exception that I mentioned before. And also we need to make sure that the threshold will be met, like all of them, as I mentioned like before. And it's also I wanted to highlight that the GAC are very open to have a discussion with the concentration party if there is like any clarity or vagueness in their transaction, and this discussion can be conducted confidentially.
Wonderful, thank you. That's very interesting on the KSA portion. How about Kuwait, Khalid? When are foreign-to-foreign transactions notifiable to the CPA?
Yeah. There are 3 things to take into consideration. First is whether the acts committed inside or outside of Kuwait prevent, restricts, or distort free competition in Kuwait. The second is, does the transaction fits with the definition of an economic concentration? Third, does the parties meet the financial threshold? If that is the case, then the parties are obliged to file an economic concentration application here in Kuwait.
Very clear, very clear. Thank you for that. We're going to move on to the next question here. Penalties for implementation before clearance. So I think the reason why we compiled this question specifically is because of the multi-jurisdictional aspect of things, global transactions. So in the event that parties decided to close a transaction and implement the transaction after they've closed, what would be the penalties there, Khalid, in Kuwait?
The CPA is entitled to take corrective actions for violations of the law. Unfortunately, specific consequences for implementing a concentration before obtaining an approval from the CPA are not provided in the Kuwait competition law. However, it's possible that the CPA would order the unwinding of a transaction for failing to comply with the procedures stipulated in the law.
Okay, so the CPA has a lot of discretion there to decide what they want to do depending on the facts of that scenario and that situation. Hussein, what about for KSA with respect to penalties for implementing before clearance? What are we looking at there? You're on mute, Hussein.
Yeah,
There you
sorry,
go.
I was on mute. So
You're
if
fine.
the economic concentration party fails to notify the GAC and they implement the transaction before they get the GAC approval, that will trigger Article 19 of the competition law, which will be the following penalties: fine up to 10% of the total annual sales value related to the violation, and alternatively a fine up to 10 million Saudi riyal, equivalent to 2,600,000 if estimating sales is difficult. And the committee can impose a fine up to 3 times the gains obtained from the violation.
Wonderful. Thank you for that, Hussein. We're going to move on to the final question on your part here. What does the review process entail? So for KSA, can you give us a summary of the filing of an economic concentration process in review with the GAC?
Yeah, sure, Asad. One of the involved economic concentration party can fill out the online application on the GAC website and to submit the required documents. And the required documents include final and executed agreement of the economic concentration, economic impact report, other relevant data requested by the GAC, legalized or apostille power of attorney from the parties involved in the economic concentration, the corporate document from the parties involved in the economic concentration, and also financial statement for the last 2 financial years from the parties involved in the economic concentration. And the involved economic concentration parties must submit the application at least 90 days before completing the transaction. And now for the filing fees, upon submission of the application, the GAC will calculate the filing fees. The fees is 0.02% of the annual sales value, capped at 250 Saudi riyal, equivalent to 66,000 US dollar, and payment to proof is required to complete the submission. And then the GAC has 19 days to review the application, and that period may pause if the GAC requests further information or document. And it's worth to mention also, if incorrect or missing information is discovered, the review period may pause too. Following the notification, the economic concentration parties can progress upon receiving written approval from the GAC, or alternatively, if there is no response within 90 days from the GAC, automatic approval is granted. And that's it, like for KSE.
Wonderful. Thank you so much for that. Very, very informative. Khalid, with respect to Kuwait, can you give us an idea of what the review process and filing process with the CPA looks like?
Yeah. Here in Kuwait, an application must be filed at least 60 days from the date of the contract or agreement related to the transaction. There are specific requirements in relation to the economic concentration filing, which are completing the CPA's economic concentration form, which consists of questions related to the parties and the transaction itself. Submitting the required documents, such as the corporate documents, the financial statements, the transaction contract or agreement, the economic dimension report, the power of attorney issued from one of the parties to the legal representative, alongside with a filing fee, which is either 0.1% of the paid-up capital of both parties of the economic concentration, or of the pooled assets of both parties in Kuwait, whichever is less and not exceeding 100,000 Kuwaiti dinars, equivalent to $320,000 US. I would like to add also that the filing fees cannot equal to zero. Once an application is submitted, the CPA have a period of 90 days, which may get extended for another 90 days to study the application. Within the review period, the transaction will be announced for any third party's objections for the period of 15 days before proceeding with preparing the report for the board of the CPA regarding the filing. I would like also to highlight that all corporate documents and the POA must be legalized up to the Kuwaiti Ministry of Foreign Affairs, and all documents that will be submitted to the CPA must be translated into Arabic by a certified translator here in Kuwait. So,
Wonderful. Thank you so much.
Yeah.
No, go ahead. You had something to finish?
I just wanted to state that this is in short the filing process here in Kuwait.
Okay. So I think what's important to note is also another distinction between the jurisdictions. Because KSA is a party to the Apostille Convention, any other country that is issuing the POA related to the filing of the economic concentration, they simply, can apostille the documents. As compared to Kuwait, on the Kuwait side, Kuwait is not a party to the Apostille Convention, and therefore the process has to go through legalization, which is a little bit longer. Usually that process takes anywhere between 2 to 4 weeks, just depending on the jurisdiction of issuance. So there's distinction again between the parties, and it goes to the timetable and time frame that you're looking at with respect to closing a transaction or that can possibly impact the transaction. Okay, so thank you, Hussein and Khalid, for that great overview of the key issues surrounding the competition laws and economic concentration filing procedures. We will now shift to the regulatory side with Shahid Slagabi, the head of the M&A department at the CPA, and Talal Lehgail, the unit head of the M&A department at the GAC. Shahid and Talal, thank you very much for taking the time out of your extremely busy day and joining us for this event. We truly appreciate that. Now, we've compiled a list of the most frequently asked questions by our clients in relation to merger control filings with the GAC and CPA, and we will be putting these questions to Talal and Shahid respectively. Just wanted to check. So with respect to the first question, the first question is for both jurisdictions, but we will begin with Shahid. Shahid, generally and most recently, how long is the filing process from submission to clearance in Kuwait with the CPA? You're on mute.
Hello for everybody. Thank you for letting us to have this opportunity to explain whether this question occurred to any companies. First of all, the CPA side, as Khalid have been mentioned within the law and within the Article 81 of the executive regulation, the filing process takes around 90 days from the date of the submission, a full application to the CPA. Sometimes it can be less. Sometimes it can be extended, whether the economic, the parties and in which relevant market we study these applications.
Wonderful. Thank you so much for that, Shahid. Talal, the same question to you, which is generally and most recently, how long is the filing process from submission to clearance with the GAC and KSA?
First of all, so Alex and Asad for the introduction, and Hussein and Khalid for defining the law and the merger and acquisition procedure in Saudi Arabia and Kuwait. Usually, we will not take more than 2 weeks if the case they don't have any harm for competition. If the document is complete from both parties, usually we issue the invoice for the transaction. And after that, if they paid, we will start the 90 days period. We will not take that the 90 days period, but during that, if we have any question, we freeze the time. Usually, if we receive application with full document from both parties, usually we take just 2 weeks if they don't have any harm from competition.
Wonderful. Thank you so much for that, Talal. Shahid, I want to come back to you. We have a specific question for the CPA. Is the CPA likely to move to an online submission system or maintain a physical submission process?
Actually, in the CPA, you have the choice to submit an application through online, or you can have it as a hard copy to the CPA office in Al Hamra Tower. And we are happy to announce that we will have the relaunch of the new website that you can submit an online application and you can follow up the procedure through online.
Wonderful. That's a welcome notice for sure. Now we're going to move on to, I have a question for Talal with respect to the GAC. Can you provide us with a brief summary of the submission process of an economic concentration application with the GAC from your perspective?
Yeah, usually when we receive an application through online platform, we review the document and see if they complete or not. And if we have a question about specific about the online application, we will back to the client and ask them to correct that answer. After that, we will issue an invoice for the application. During the study, we define the market from product side and geographic side. And if we see any concern from our side, we freeze the time and ask the client to have a meeting, ask them about specific about our concern. And if we see that they will have a high market share after merge, that gonna have we will have concern about that. And after we define the market from product side and geographic side, we see the competitors. Maybe we will ask the competitors about the transaction, ask the regulator, for example, if in telecom sector or something like that, if they have any concern about the transaction. And after that, we will issue our decision in the transaction.
Okay, thank you so much for that. I think that's very interesting to hear it from your perspective and the regulatory side of things. Talal, we're going to stick with you for this next question for the GAC. You know, we understand that part of the required documents to submit to the GAC or for the economic concentration application is a finalized and an executed agreement. Now, is it possible to provide an unexecuted draft of the transaction document as part of the application instead of an executed one?
Yeah, always I receive that question. But the reason behind that, because we would like to have a final look for the transaction. You know, the draft or something, the SPA is not finalized yet. Maybe they're going to change the percent of the acquisition. And that will be not notifiable. For example, if company would like to by 10% of other company, the case is not notifiable. But what if they increase their share from 10 to 40 or 50? That will be notifiable according to the law. And that's the reason behind we ask for the final agreement between the parties and should be signed between the parties.
Yeah. I mean, those are fair points. I can't argue with you there, Talal. So I had to ask the question. Okay, we're going to move on to a question for the CPA and Shed. Shed, the next question is for you. For non-Kuwaiti economic concentration applicants, they must legalize the relevant POA in the corporate documents. Will the CPA begin processing the application with initial notarized documents contingent upon the applicants providing fully legalized versions? And I see you shaking your head already, like this is this is not going to happen. So
I think you get the answer.
I'll leave you to tell them.
Okay. According to the law and the executive regulation, all documents submitted to the CPA must be fully legalized for the application to be considered as a complete filing, also to be translated to the period of the review to start and to be completed application to get the period started.
Okay, thank you so much for that. I appreciate it. Shahid, we're going to also stick with you. I have another question for the CPA. Does the CPA recognize the joint venture principle of full function, wherein the joint venture must be a full function joint venture in order to be notifiable? And I have to say, I get this question quite a bit from clients.
But according to the Article 10 of the law, specify the types of the economic concentration to be like the merger, and we have the acquisition. So the joint venture is one of the transaction to be considered at the one of the form. They should be submitted an application to the CPA.
Okay, understood. So a joint venture is a joint venture for the CPA. There's no distinction there.
Yes.
We will move on. Thank you so much, Ed. The next question is for both jurisdictions, but we will begin with Talal. With respect to notifiable foreign transactions, what type of penalties or sanctions have you been able to implement against those parties in the event they failed to file or close the transaction prior to receiving clearance from you?
Okay. I just want to start with the Saudi law. They don't have any carve-out for transaction. I know some authority in the world have carve-out after they will complete their transaction and they will wait to do their transaction in that area. But in Saudi law, they don't have the carve-out, and I think we will not, according to the law, if you complete your transaction before you get clearance from the GAC or the document, you are against the law, and you can apply. You will fine for that. As I mentioned earlier, 10% of according to Article 19, 10% of their sales, or if it's very hard to collect that, 10 million riyal Saudi. If I would like to do GAC always review the transaction and see if the transaction done before or not. If you foreign company, for example, done their transaction without getting clearance, and GAC isn't look at for that transaction specific, the company have option to go to settlement before GAC asks them why you don't apply for that transaction. And settlement is, I think it's a good choice for the company, better than GAC come to the company and
Okay. If I can ask you just to speak up a little bit, Talal, some viewers are having a hard time hearing you, but I think I heard you with respect to that.
Sorry,
if you could
it's clear, or you need you need.
No, you're clear
to
now.
repeat
You're
the
clear now.
comments?
Yeah, no, thank you so much. So you're clear
Sorry
now.
about that.
No, you're fine. You're fine. Thank you for that. I think it's important to note, Talal is basically letting you know that it's better for you to come to them than them to come to you. That's always a good thing. Now, the same question for you, Shahid.
If you allowed me, Asad, because
Sure.
I read some comments, they didn't hear my voice clear. I will repeat the answer if you allowed me.
Please. Absolutely. Go ahead.
Okay, first of all, I just want to say in Saudi law, we don't have a carve out. I know some authority in the world have the carve out option for the company, and they will do their transaction with in the world, and they will wait the clearance from the specific authority until they receive the clearance. In Saudi law, we don't have that. And if the company complete their transaction without getting clearance, we see that is against the law, against competition law. And that means that they did their transaction without getting a clearance from GAC. That maybe will suit the company according to Article 19, 10% of their sales, or if it's very hard to collect that, 10 million Riyal Saudi, which is $37.7 million. Also, there is a good option for the company, for a foreign company, if they did, if they done their transaction, and before GAC asked them about why you didn't apply for that transaction, they will go to GAC and settlement, and always settlement is a good choice for company, better than get a fine from the authority.
Thank you so much for repeating that answer. We really appreciate that, Talal, from the KSA side. Very, very interesting. Now, Shahid, if we can move on to you, same question to you with respect to Kuwait and the CPA. With respect to notifiable foreign-to-foreign transactions, what type of penalties or sanctions have you been able to implement against those parties in the event they failed to file or close the transaction prior to receiving clearance?
Yes, failing to notify about concentration, like a merger or acquisition, it should be like the gun jumping. When secure, it should be has a penalty provided by the law, which is not to exceed 10% of the total revenue of the economics financial report in the past year, and should be goes to the Majlis al-Ta'dib, which is the council that will be, to get this sanction. And we don't like the parity, if they do gun jumping, whether it's a foreign or a Kuwait-based company, it's the law based on both of them.
Applies to the same. Okay.
Yes.
Thank you so much for that. Shahid, we're going to also stick with you. We have a specific question for the CPA. Article 12 of the Kuwait Competition Law requires the applicants to calculate the application fee based on 0.1% of the paid-up capital or of the combined assets of the parties, whichever is less. And obviously, there's a cap there under the law of 100,000 Kuwaiti dinars. The question is, and we get this a lot from non-Kuwaiti clients, is why they cannot base the calculation fee on the paid-up capital of just the relevant Kuwaiti entity or the turnover in Kuwait alone.
Because based on the Article 10 of the law state that the party in the economic concentration transaction must pay the fee for the concerned to be parity, whether they are going to sign this contract or sign this economic merger or acquisition, and the asset, it should be above the Kuwait. This is the way how the law have been established to set the fee about the concentration application.
Okay, so the concern then is with the parties that are the listed in the transaction or the signatories to the contract. Those are the relevant parties. Yeah.
If they choose to pay about the capital of the company.
Correct.
But if they choose to pay about the asset should be on the relevant company in Kuwait, based on Kuwait. Also, it should be submitted with them a report, asset valuation report.
Right. Correct. Thank you so much for clarifying that. That's clear. Okay, we're going to move on to the next question. And I think Talal alluded to this a little bit ago, right? And again, this question is for both jurisdictions, but we will start with Talal. Very popular question. He's smiling ear to ear because he knows that he gets this question all the time, right? So I think, these global transactions and the foreign principals have, they enter these transactions with multiple jurisdictions and they have their closing dates and they would like to find some kind of a way to carve out or close the transaction for at least some of the jurisdictions, and the ones that are taking longer to receive clearance, they want to carve those out and have a second closing. So in Kuwait, or I'm sorry, in KSA, Talal, you alluded to this, and I want to kind of open the floor to you, and maybe you can discuss it in a little bit more detail as to, is this allowed under the law? Do you have any type of recommendations for these parties with respect to carving out? The floor is yours.
Okay, unfortunately, we don't have a carve-out in Saudi law, but I always recommend the company apply for the economic concentration before they have a closing, before a month or 2 months before the closing day. Usually we count that. I know there is some specific case, like for example, in the stock market, and you need to finish that. We count that, and if we have a hunt for competition, it's very hard to finish it within a week or 2 weeks. And the reason behind that, you have to apply before time. Usually we don't take the 90 days period actually, but my recommendation for company, apply before that. I know.
I can't argue with you. It's clear. You're very clear when it comes to that. So okay, fair enough. Shahid, the same question to you with Kuwait. Are there any avenues to carve out transactions with multi-jurisdictions involved?
Each case is studied individually by submitting they can submit a pre-notification application to the CBA, which will be followed with the decision issued for the competition.
Okay, noted on that side. And the CPA has been so wonderful in responding to any queries with respect to the parties. If something applies, if it doesn't apply, they've been very helpful on that front, and we always truly appreciate that. Shahid, we're going to stick with you for the next question, and for the future outlook. It's a question that has 2 sub questions, but we'll start with the first one. In relation to future outlook, what would be one thing you would like to see changed in the application process?
Currently, CPA is working on reviewing the application and also to make the guideline that we will establish, and to be easier for all the company to submit any or to have the answer about any situation. Also, again, we study case by case, and also are working on, let's say, reviewing all the regulation to make sure that it's be easier for the company to submit any application.
Okay, thank you so much for that, Shahid. No, that's very interesting because I know KSA, obviously you have your guidelines along with the law and executive regulations, quite extensive on the KSA side, very helpful with examples as well. So that would be a welcome addition for Kuwait, for sure. And I think you also answered, Shahid, if there are any incoming amendments to the law, practice, and implemented soon. So hopefully we'll see those guidelines very soon for Kuwait. If we can shift over to Talal, the same questions, in relation to future outlook, what would be one thing you would like to see changed in the application process with the GAC?
I just want to see if we receive application, it's clear and complete from the client. We don't want to back and forth for them before starting the 90 days. I just want to, since we received the application, issue the invoice and start the 90-day period. We don't want to lose that time for client and for company to ask them the document. No, it should be clear that you don't upload, for example, for the economic report. We just want to, when we receive the application, is complete and clear from the company.
Understood. Thank you
Also,
for that.
we don't want to lose the time for company. We just want to, since we received the application, start the 90 days.
Yeah.
We see some issue when issue the invoice. The client they didn't pay for that. And take 2 or 3 weeks to pay. We don't want to lose time.
Okay. No, and I think that's very important because that goes, to the heart of the issue that surrounds this, which is time frame. Everybody wants to finish as quickly as possible so they can close the transaction. So I think you're 1,000% on point there with respect to that. Now, are there any certain income amendments to the laws and practice that are coming soon that we can get a glimpse of or anything like that?
Me or Shahad?
To you, it's a lot to you.
Okay. We will do something on joint venture and investment fund, maybe in quarter 2. Also, we review, and also usually when we would like to follow the international practice. We will do something on for joint venture. We will clarify for that. Also for investment fund.
Wonderful. That's definitely good to know. I think that is it for the questions, but I did want to open the floor to either Shahid or Talal. If you guys had anything else you would like to share with us, we'd love to hear from either of you.
I just want to tell any company our floor is open usually. If you see your transaction if you are not sure about the transaction is not viable or not, you can have a meeting with us and pre-notification and share some document before apply for economic concentration through the system. You can have a discuss with the authority if the case is not viable or not, which the document should be in this case, and our floor is always open.
Wonderful. Thank you for that. Shahid, if you have any final remarks you would like to give.
Yes, I would thank you for letting us explain any question toward or the company. Also on the CPA, we have the option that you can have a pre-notification, also to ask any question about the document should be submitted, about the particular market. Also, I want to assign that the CPA law, it's toward the companies. It's aiming to have a fair enough market to be all companies to compete in a good matters, not having any anti-competition behavior. That's why it will be a pre-notification before you do any transaction. And this is the main wise about this the CBA having a mergers and acquisition regularity guideline or law. Also, we are open to have any questions, and you can feel free to have any question, you can answer it.
Okay, thank you so much for that. I really appreciate both of you so much, and thank you again for joining us, taking the time out. I know Shahid had her big meeting today, so they sprung it on her out of nowhere. But it's always a pleasure working with both of you. You're always very clear and concise with your feedback to us, and we really appreciate that. Please, just a reminder to the attendees, if you have any questions, submit those questions to us in the dialogue box. We will work with Shahd and Talal and provide responses thereafter. And I will hand it off back to our managing partner, Alex Sada.
Thank you. So that's very helpful. And yeah, just to let you know, we are, with respect to all the questions we've seen so far in the chat, we will be getting back to all of these questions. I just have always made it a policy to try to keep webinars within 1 hour, because I know people have busy schedules and whatnot. So we'd love to go through each and every one of them, but the time just isn't going to allow us to do so. But I promise we will get back to each one with whether, and we're going to be bothering both Talal and Shahad for their input on the same. So we can assure you of that. And as we draw to a close at this point, I would like to extend my sincere gratitude to our distinguished speakers, both Talal from GAC and Shahad from the CPA, as well as my esteemed colleagues from GLA for their invaluable insights and contributions to today's discussion on merger control in the GCC. Today's webinar has shed light on the evolving regulatory landscape in these two states of Saudi Arabia and Kuwait. And as we've delved into this crucial role of effective merger control regs in fostering fair competition, preventing anti-competitive behavior, and ultimately contributing to the continued growth and diversification of the region's economy. The GCC has undeniably experienced remarkable growth and attracted substantial foreign investment. And it's created a very competitive business environment. It's clear that the need for this robust merger control mechanisms have become more pronounced than ever after listening to these discussions. And I, as I said before, I'm truly amazed by the development and growth of the regulatory bodies in general in the GCC that I've seen over the last several years. The commitment and dedication shown by the regulators and the industry professionals alike are truly commendable, and I'm confident that our collective efforts will continue to strengthen the regulatory framework and promote a level playing field for businesses in the region. So as we conclude today's seminar, I want to encourage all of us to remain actively engaged in this ongoing dialogue surrounding merger control issues in the GCC. By fostering collaboration, sharing insights, and staying abreast of regulatory developments, we can collectively contribute to the advancement of fair competition and sustainable economic growth in the Gulf region. And once again, I'd like to express my deepest appreciation to our distinguished speakers, my colleagues, and all of you for your participation and engagement in today's webinar. I'm confident that the knowledge and perspective shared today will serve as a valuable foundation for our continued endeavors in the field of merger control in the GCC. Thank you, and I look forward to our continued collaboration in the future.
Thank you so much, everyone. We appreciate it.
We're going to be signing off, and again, we will get back on all questions raised in the chat. And even afterwards, if you think of things that you'd like to pose, email us, and I assure you we'll get back to you shortly. Thank you for your time.
Thank you, guys. Appreciate it. Thank you, Talal. Thank you, Shahd.
Thank you.